bodies, both locally and internationally. She's a fellow of the Institute of Chartered. She's a member of the Chartered Institute of Arbitrators of Nigeria. You can keep clapping. She also belongs to the National Association of Women Judges in Nigeria. Keep it going. The International Association, the International Bar Association, the Commonwealth Judges and Magistrates, the Magistrates Association of Nigeria, Lagos branch, a highly disciplined and intellectual-driven legal professional. Justice Olufunke Sule Amza combines judicial competence with compassion, scholarship, and a passion for alternate dispute resolution, access to justice. She remains committed to upholding the rule of law, advancing judicial integrity, and contributing meaningfully to legal development and societal progress in Nigeria. My DG and all Rotarians present here today, I am very proud to have the singular honor to introduce to you Honorable Justice. Thank you, my Lord.
I thank you so much. I thank you for this citation that was very. Judges are used to delivering judgments. And I have something that looks like a judgment to be delivered. But today, I'm not delivering judgments. I am raising conversation that would stimulate and encourage us to impact our society more. Distinguished Rotarians, it is indeed both a privilege and a profound honor to stand before this beautiful assembly. The Rotarian movement for over a century has been one of the world's most enduring symbol of service. And this I have seen and heard while seated there. I've heard so much and I am so encouraged. Your motto reminds me that the greatest among all are those who give themselves or give their strength, knowledge, and influence towards lifting others. It is in this very spirit that I bring before you today a conversation that lies in the intersection of law, humanity, and justice. The theme of this paper is access to justice, bridging the gap for the vulnerable. This is a moral imperative. It is a call to action that resonates with everything that Rotary stands for. Justice, as we were told, is blind. You see the Lady Justice, that is usually blindfolded. That's the symbol of justice. But too often in our society, justice is not only blind, but it is also silent, slow, and scandalously inaccessible to those who need it most. The poor widow who could not afford the services of a lawyer. The child whose custody fate is being decided without being asked of his or her opinion or who he or she would prefer to stay with. The domestic violence survivor who does not know what the law or what law can protect her. Or these are not distant statistics. They are our neighbors. They are members of our immediate community. They are people that Rotary exists for. This paper is therefore a conversation, scholarly in its foundation, but urgent in its human implication, about how we, you and I, as professionals, community leaders, and people of influence can work together individually, collectively, to ensure that justice is not a luxury available only to those who can afford it, but a right that is accessible to the ordinary man on the streets. In interrogating this, I first go into what do we understand by access to justice? Access to justice I have defined here as the ability of individuals regardless of their economic status, gender, age, ethnicity, religion, or educational background, to seek and obtain remedy through formal and informal legal institutions whenever their rights are infringed upon. This encompasses far more than simply having courts in existence. It means that those courts must be physically accessible, financially affordable, linguistically comprehensible. I noticed a couple of people that have spoken to me today, the pronunciation of some words, the legalese that we engage in, how the ordinary man on the street understands all of this. The United Nations Development Program defines access to justice as the ability of people to seek and obtain remedy through formal or informal institutions and in conformity with their human rights. This definition is crucial because it recognizes two principal truths. First, the formal court system. That the formal court system are not only the legitimate avenue for justice. Second, that the standard against which justice is measured must always be that the right of an individual is protected, not just by legalese or speaking English that the ordinary man would not understand. Goal 16 of the United Nations Sustainable Development Goals specifically calls on nations to promote peaceful and inclusive societies and provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. Access to justice is therefore not a peripheral aspiration. It is a global developmental priority. Now, narrow this to our own landscape, to Nigeria as a nation. Nigeria as a nation has approximately 220 million people endowed with abundant human and natural resources, a dynamic legal profession, and a constitutional framework that on paper guarantees fundamental rights to every citizen of this nation. Section 6 of the 1999 Constitution vests judicial power on the courts. Chapter 4 of that same Constitution enshrines an impressive catalogue of fundamental rights, i.e., the right to life, right to dignity, right to fair hearing, and freedom from discrimination. Yet, the gap between these constitutional promises and the lived experiences of the millions of Nigerians is vast, painful, and growing. Considering the following realities, I have itemized a bit here. Nigeria has fewer than 6,000 registered legal practitioners per state on the average, in a country where the legal need is enormous. The ratio of lawyer to citizen in the rural area is even more alarming. The backlog of cases in our courts is staggering. Cases that should have been resolved in months lingers for years. People trade blame. Some blame the courts and some blame the practitioners. I refuse to comment on this. Sometimes it takes decades. The cost of legal representation places justice beyond the reach of the majority. A family earning the national minimum wage of 70,000 naira per month, retaining a counsel for even straightforward matters may consume several months of that particular salary. The legal aid services, though provided for under the Legal Aid Act 2011, remains chronically underfunded, understaffed, inaccessible to most Nigerians. In our plural legal system, where the statutory law, customary law, and Islamic law coexist, many vulnerable persons, particularly women and children, find themselves navigating completely legal dynamics without guidance, proper guidance, and often to their severe advantage. The Justice Reform Assessment conducted over the past decade consistently revealed that the most marginalized Nigerians are women, children, persons with disability, and rural dwellers. Their grievance, most often than not, go unheard. Their rights go unenforced. Their lives are diminished, not by the absence of the law, because we have the law, the legal framework in abundance in Nigeria, but by the absence of access to justice itself. Now, who are the vulnerable? Before we can bridge the gap, we must understand who among the populace are more likely, are most at risk, or at risk of being left behind. In the Nigerian context, vulnerability in the justice system is not just random. It is patterned, structural, and often cumulative. Those who are economically disadvantaged are also more likely to be educationally disadvantaged. If you are educationally disadvantaged, you are less likely to know your rights. Those who do not know their rights are less likely to seek legal redress. And those who do not seek legal redress are more vulnerable to further exploitation. It is a cycle that perpetuates itself with devastating efficiency. The primary category that I've listed here of vulnerable persons who faces systemic barrier to justice are as follows, but not limited to what is stated here: women and girls. The women constitute over half of Nigerian population, yet they remain among the most systematically disadvantaged in the justice system. Gender-based barrier to justice operates in multiple levels. Economically, women are more likely to be financially dependent, making litigation costs more prohibitive. And culturally, women are frequently discouraged from pursuing legal remedies, particularly in family disputes and domestic violence cases. Also in inheritance cases, the social stigma, family pressure, community expectation of silence and endurance. I'm sure it is common knowledge that even when a woman goes through pain in the marriage, the easiest advice given to by anyone is just manage it and be quiet. Just even when the woman, I watched a movie recently, and the mother-in-law was advising, the woman was complaining that my husband beats me a lot. The mother said, please go see it out. Even my own, that means the husband's father, beats me too. And I did not die. You will not die, you will be fine. The reasons are very consistent. Fear of further violence, lack of legal knowledge, distrust of the institution, and prohibitive cost of accessing formal legal process. Two, the children. Children are among the most legally invisible members of our society. They cannot initiate legal proceedings in their own name. They cannot retain counsel. They often cannot articulate their rights, even when those rights are being violated before their very eyes. Yet, they are profoundly affected by the legal outcome in custody proceedings. Also in child labor cases, matters of inheritance, educational disputes, in cases of abuse and neglect. The Child Rights Law, the Child Rights Act of 2003, which domesticated the United Nations Convention on the Rights of the Child, guarantees children the right to be heard in all matters affecting them, including custody cases. Yet, in practice, the voice of these children are rarely sought, rarely recorded, and rarely acted upon in the Nigerian Family Code. We as judges, we make life-altering decisions about the future they will inhabit. without asking the children. Even when we ask, what reliance do we place on the views of those children? 3, the poor and economically marginalized. Poverty and justice exist in inverse proportion in our society, and Nigeria is no exception. The poor are more likely to be victims of crime, exploitation, land grabbing, wrongful decision, fraud, and so on. Yet, they are the least equipped to navigate the legal system. The cost of filing fees, legal representation, transportation to court, the time lost from income generating activities creates an insurmountable barrier for many. The Legal Aid Council in Nigeria that was established and was designed to address this gap, but its reach remains tragically limited. Now, the anatomy, I go straight to the anatomy of the justice gap itself. What creates this gap? How did we find ourselves there? I have written here the financial barrier, which I've expressed and stated earlier, that the commercialization of justice is perhaps one of the most pervasive barriers. Legal fees, cost of filing, transportation, multiple adjournments, all these inhibit access to justice. The geographical barrier, the distribution of courts in Nigeria has historically followed the colonial administrative pattern that concentrate legal infrastructure in urban centers. So what happens to the ordinary man in the rural village? Institutional delay. The maxim, justice delay is justice denied, which is has been embedded in the consciousness of every law student. Any law student will tell you this maxim. But the chronic congestion in our courts is the product of the inadequate judicial manpower, insufficient court infrastructure, procedural inefficiency, a culture of routine adjustment. Even when you want the matter to go on, the lawyer will come up and say, if you want excuse or the other, and you will not have a choice but to adjourn. If you insist, counsel, you must go on with this matter. Oh, they write a petition and say the judge is interested in the matter. It's their case. You conduct your case the way you want to. But this delay itself equates denial of justice. Legal illiteracy, the right that is unknown, is a right that cannot be exercised. Legal illiteracy, the widespread of lack of knowledge about one's legal rights. The mechanism for enforcing it is one of the most profound barriers to access of justice. Millions of Nigerians do not know that they have constitutional right to fair hearing, even when they know what is the definition, their understanding of the said fair hearing. A lot of Nigerians are not aware that free legal aid is available to those who qualify or who ask for it, that domestic violence itself is a crime and a criminal offense under several state laws, that a landlord cannot evict a tenant without due process. Now, if the landlord could wake up, increase rent, and if you are not able to pay, someone was saying something about a landlord going to put a lock on the door and say, you can't come into my house, or they'll throw the things out. How many people are aware? Or that an employer cannot terminate employment without following statutory procedure. This ignorance is not a personal thing. It's a systemic one. It reflects the failure of our educational system, our legal institution, our government to invest in adequate legal public education. It also reflects a legal culture that has historically treated the law as the exclusive province of the state. We have the cultural and gender barrier. In many Nigerian communities, cultural norms actively discourage the pursuit of legal remedy, particularly by women. Seeking legal redress for domestic abuse may be framed as a betrayal, challenging customary inheritance that disinherits daughter may be framed as disrespect to tradition. Pursuing custody of one's child through the court may be framed as aggression or inappropriate. This cultural framing do not merely discourage individual action, but they construct the entire social environment in which the exercise of legal rights is socially penalized, particularly for women. Access to justice in family law, under family law, having presided over the family court for over 8 years, I consider it imperative to draw focus attention to the persistent access to justice gap within the domain of the family law. This area of law, perhaps more than any other, engages directly with the life or lived reality of the society, the most vulnerable persons, particularly women and children. Yet it remains as one of the least accessible in practical terms. The Nigerian legal framework governing custody is fragmented, inconsistently applied, and profoundly shaped by customary and religious norms, and varies across the nation because of our plural legal system. In Lagos alone, the outcome of custody cases differs markedly. For most parents, particularly mothers, navigating this system is practically impossible. Also, many survivors of domestic violence do not know that the law protects them and that they can actually report and have free legal counsel. The inheritance rights of women and children, inheritance law in Nigeria represents one of the sharpest fault lines in access to justice landscape. Under many systems of the customary law, women do not inherit from their husband or fathers. Women may be dispossessed of their matrimonial property at the death of the spouse by a relative invoking customary section rights. Female children may receive nothing, while the male heirs takes almost everything. In some communities, these practices persist with the tacit acquiescence of the local institution and the explicit endorsement of the community authorities. Section 42 of the 1999 Constitution and the Married Women Property Law should, in principle, protect women's inheritance rights. But for a widow in the rural community who does not know of the existence of these laws, cannot afford a lawyer, or face a community that has united or decided to gang up against this constitutional provision or rights are nothing but very cold. Our access to justice is blocked, not by the absence or the non-existence of the law, but by the absence of knowledge and resources or institutional support that she requires. So, how do we bridge this gap? Having stated or mapped out the dimensions of the problem, we now turn to the solution, and I want to be clear. The solution actually exists. The justice gap is not inevitable. It is not natural, and it is not acceptable. It's a product of choices. Choices about how we allocate public funds or resources, how we structure the legal institution. I have itemized some roadmaps that can help us in bridging the gap. Strengthening the legal aid. The most direct intervention is obviously adequate funding and expansion of the legal aid service. The Legal Aid Council of Nigeria must be resuscitated to fulfill its statutory mandates. This requires the following: significantly increasing budgetary allocation at both state and federal level, expansion of the council's scope to cover also civil matters, because what they concentrate is helping people to get bail, those basically concentrating in respect of criminal defense. Partnership with the Legal Aid Council, between the Legal Aid Council and the Nigerian Bar Association, to facilitate the pro bono representation by private practitioners, establishing legal aid clinics at local government areas staffed by trained paralegal under supervision of qualified lawyers. Technology-enabled legal aid. The Rotary Club across Nigeria can play a direct role by sponsoring legal aid clinics, funding paralegal training programs, advocating state and local government to increase the aid of legal aid, to increase the budget for legal aid. Investing in public legal education, knowledge is step to justice. Population that knows its rights, the population that can defend or stand for those rights. Legal literacy program delivered through schools, community centers, religious institutions, our churches, the markets, radio, television must become a national priority. And the key messages should be: every Nigerian has the right to fair hearing under the Constitution. Domestic violence is a crime, not a private matter. You find a woman who has been beaten black and blue, go to the police station, and the police will say, "You're beaten by your husband." He said, "Don't, it's a family matter, you can go." No, it is not a private matter. Children have legally enforceable rights, which includes the right to be heard in proceedings that affect them. You choose to fight is your problem. These children must be heard also in custody matters. Children, women have equal inheritance rights under the federal law, and it should be so all through the country. Legal aid is available free. Those are the campaigns I expect to go on. These efforts with clubs in virtually every state and membership drawn from professional elites and the traditional community service. Rotary has both the reach and the credibility to make legal literacy a cornerstone in its service agenda. Imagine a Rotary legal literacy campaign conducted in partnership with the local bar association, reaching thousands of Nigerians in the market, mosques, churches, community halls, with simple but transformative message. You have rights, and here is how you can enforce those rights. You can imagine how far that will go in this country. Expanding the alternative dispute resolution. Not every dispute needs to go to court. Indeed, for many disputes, particularly family-based one under family law, land matters, some commercial disagreement, mediation, arbitration, and community-based disputes resolution mechanism may deliver faster, cheaper, and more enduring outcomes. The former litigation, expanding access to alternative dispute resolution, is therefore a critical component of the access to justice agenda. The multi-door portal system pioneered in Lagos State represents a model that should be replicated and strengthened across all the states in Nigeria. By providing a range of dispute resolution pathways, mediation, arbitration, early neutral evaluation, and a mini trial, the multi-door courthouse system reduces the burden on formal courthouses and provides more accessible justice option to the ordinary man on the street. Rotary can support the expansion of ADR by doing the following: funding the establishment of community mediation centers in underserved local government areas, supporting the training of community mediators, particularly women, in basic dispute resolution, advocating for mandatory pre-litigation mediation in family law, land disputes, this will reduce unnecessary court congestion, partnering with law faculties and Chartered Institute of Arbitrators in Nigeria to increase the pool of qualified arbitrators